the developments of the DOL's Fiduciary Rule since the very beginning. And as you all are aware, now the rule will not be delayed again. So beginning June 9th, 2017, new documentation will be required when selling fixed indexed annuity business from a qualified source. This also applies to qualified money being used to fund a life insurance policy. We have a lot to cover today, so I'll quickly turn the call over to Lori Beck. Before I do that, I wanted to point out that we will do our very best to answer your questions towards the end of the call. And so please submit your questions through the GoToWebinar menu that you see on the right of your screen. At Insurance Network America, we do take great pride in providing you with the knowledge, support, and the tools you need to be ready for June 9th. In your practice, whether you're a registered rep, you're an IAR working for an RIA, or you're an insurance-only professional, at the conclusion of today's call, our intent is that you will have a clear roadmap to follow as you continue to thrive in your practice. So at this point, I would like to introduce our President and Chief Operating Officer, Lori Beck. Thank you, Lori.
Yeah, thank you, Tom. And I would echo everything that Tom said. You know, we're in our 30th year of serving the needs of independent advisors as an independent marketing organization. And this webinar is just one in a series designed to bring you the information you need, because we know that what you need is to be able to focus on what you do best, which is serving the needs of your clients. We do have a ton to go over today. I'm going to try very hard to keep it on pace and keep it on time. We will answer questions at the end of the call, time permitting. Keep in mind that if you ask a question and we don't get to it, that question is recorded, and we will not recorded literally, but it's recorded in our system, and we'll be able to get back with you and answer that question for you on a one-on-one basis. So please make sure you let us know what's on your mind. This webinar and all of the others that we have done are all about you and what your questions are. So please make sure if we don't cover something, you get there. What are we going to cover today? Well, we're going to talk about exactly what is going to happen next Friday. We're going to talk about what happens the day after the rule goes into effect, whether or not we expect market disruption. If so, how much? Why is there market disruption? We're going to talk about these rules around this new term, reasonable compensation. Some questions you might be asking your coverage, your insurer for your E&O policy. And then another thing that we get a lot of questions on is, you know, I get all of this applies to certain qualified money. Can I have a different process in place for non-qualified versus qualified? We'll touch on that just slightly. We'll talk about what we have available to help our advisors on June 9th. I know there are a lot of people on this call not currently working with Insurance Network. That's fine. We are happy to provide this information for any advisor that needs it, whether you're working with us or not. But if you are working with us or have an interest in working with us, we're going to talk about some things we have available to help you. We're going to talk a little bit about the future of the rule, what we're hearing in the marketplace. Tom, as he indicated, Tom has stayed really in front of this. Our annuity specialists have stayed really in front of this for several years, as have I. I am on the board of directors for the National Association of Fixed Annuities. I had a call again this morning on this very issue, just trying to understand the kind of the temperature and what's going on back in Washington, D.C. So we'll touch on that real briefly, time permitting. And then we'll talk about what we believe your next steps should be going forward. So let's start really at what is the status of the rule itself. You know, as we've talked about in other webinars, this rule was actually effective last year. So it was effective April of 2016. And this is partly why this rule has been so hard to roll back. A lot of people know that when President Trump took office, he signed an executive order stating that any pending new rules that had come out of the administrative rulemaking of President Obama were to be held off, stopped, not implemented until further review could be done. Many people thought that this rule fell into that category. It did not, because the rule was actually effective. its applicability date was supposed to be 1 year following its effective date, so its applicability date was supposed to be in April of this year. We did get a 60-day pushback to June 9th. A lot of people expected a second pushback. Didn't happen, so here we are. And then January 1, 2018 is when the full applicability of the bill kicks in. Now, there have been lawsuits, and right now we are 0-4 on the lawsuit. So far the government has been winning. There are new briefs coming and to be filed in July. Too late for the June 9th. And with the fact that the new administration didn't give us that second delay that many people were counting on, I think the message that we have to understand here is we can't just sit back and hope that it's going to go away, because it isn't going to, at least not now. So before we go into the full agenda I've laid out, given that we literally have over 200 advisors on the call who this is their first webinar, at least of ours, I want to do a really fast recap on some of the major aspects of the rule, and then we'll move forward to the rest of our agenda. I'm going to go over it real quickly because we have covered it in the past. But if you need more of a background information on the rule than we can cover today, again, call our office. We have annuity specialists who have spent a ton of time researching this, understand the rule, understand what you need to know. Call them, call Tom. At an insurance network, our advisors always also have access to me. Even though I am, President and Chief Operating Officer of the company, my number one goal, my number one love is to work with advisors. So all of us are available to you if you need our help. So affected plans, it affects IRAs, HSAs, MSAs, educational savings accounts, solo plans, 401ks, and any plan to be funded with a rollover from one of these plans. I get asked a question a lot, what about 403Bs? They're qualified plans. Well, 403B to 403B or brand new 403B accounts, not affected by this rule. However, if you're rolling money from a 403B into a new IRA, it would be affected by this plan or this rule. Additionally, life insurance, for example, if you are using required minimum distributions out of a qualified account to fund a life insurance plan, it would be affected by this rule. Today, in order to focus on the accounts that impact most of you, we're going to spend our time talking about the rules impact on IRA rollovers from 401k, IRA to IRA direct transfers, and new IRA accounts. Just trying to keep in touch with, really how much time we have. So given the fact that a significant part of our industry is impacted, why is it that we get a little frustrated when we know that some of our competitors are telling their advisors that this rule should be ignored and everything is business as usual? Well, that's partly because under this rule, when an advisor becomes a fiduciary, that advisor's conduct is then governed by the fiduciary prohibited transaction rules in ERISA and in the Internal Revenue Code. And generally speaking, these rules prohibit you from receiving payments from third parties, including insurance commissions. Literally, you can no longer receive an insurance commission as of June 9th unless you meet the requirements for one of two exemptions in the rule. These exemptions are known as 8424 and BICE or BIC. You might have heard it said a couple of different ways. So 8424 states that you may receive compensation such as commissions if you, in writing, acknowledge to your client that you are a fiduciary and agree to adhere to the best interest standard of care. You also may make no statements that are materially misleading. And the failure to describe a material conflict of interest is deemed to be misleading. And we'll get more into that in just a second. You must also disclose your compensation, which, by the way, they consider to be a potential conflict of interest, and any other potential conflicts of interest you might have. Before the sale is finalized, these disclosures must be delivered to the IRA owner in writing, and they must, in writing, acknowledge receipt of those disclosures. In addition, even if they've agreed that your compensation in their mind is reasonable, the federal government now gets to decide, because they state that the advisor's compensation must be no more than reasonable, and that the advisor cannot receive any additional financial incentives such as trips, awards, or bonuses that are based on production levels. In general, these are no longer going to be allowed. This means that carriers have had to take a look at any variable compensation offered to their agents and to marketing organizations like Insurance Network. And marketing organizations have had to evaluate the extras we provide when you write qualified business with us. Now, this does not mean you can't earn these things, and it does not mean we won't be able to host them or offer them. It simply means we have to take a look at how you qualify, and on trips, what the primary focus of the trip is. So while they may change, we do not expect our ability to provide extra value to you to go away. In fact, we believe that you're going to need help more than ever. So we will be working harder than ever to find ways to make that happen, keeping in compliance with the rule, making sure that we all stay out of trouble. When the rule was delayed to June 9th, there was a requirement initially of a transitional BIC for indexed and variable annuity sales. This transitional BIC has been delayed and in fact eliminated. We now go from 8424 rules for indexed annuities straight to the full-blown BIC on January 1st of 2018. So there is a transition BIC that is out there. There are some things involved with that, and depending on the products that you're selling, this may apply to you. But again, in the interest of time today, since indexed annuities, life insurance, fixed annuities, SPIAs, all of the products that we market through Insurance Network, and most of the people on this call are doing business with, we're not subject to this transitional BIC anymore. And again, I'm going to get to everything. I'm just kind of doing a fast recap. So hopefully I'm not going too quickly. So here we go. Despite any delays, the full-blown BIC is going to be required for indexed and variable annuity sales beginning in January. And it is much more detailed than the transition BIC was, and most importantly requires signatures of both your client and an entity that you're going to have to designate as your financial institution. That financial institution may be a carrier who might be willing to do so. A financial institution might be a bank if you're an employee of a bank. It might be an insurance carrier. It might be your broker-dealer. It might be your RIA. At this time, there is not a single marketing organization in the country who has the legal right and ability to be your financial institution. That's a whole nother subject we can't get into, but the Department of Labor has made that particular thing much more difficult than we all thought it would be. So right now, that isn't the case. We're still battling for that, but for now, you would have to name one of these other entities as your designated financial institution. So what is a BIC? Well, a BIC is a written contract executed at the time of policy issuance, which must include the following. It goes back to definition in terms of the fiduciary standard of care, provides some of the same disclosures. It also requires mandatory arbitration be no longer the only avenue available, and actually opens up the rights to class action lawsuits. And this is where a lot of people have really been stressing a bit about this BIC, and I'll talk about that in just a second. Other things within the BIC are transaction disclosures for each investment, focusing on the fiduciary standards and conflicts for that transition or transaction. And this is why there is this talk about grandfathering and talk about this one-year relief rule. If you were to sell an annuity to somebody on January 2nd, and on March 25th, they ended up with some additional qualified money coming out of a 401k or something else, and they chose to put that money into the annuity you sold them, there is a one-year relief there isn't a second BIC required. But according to this new rule, if they waited a year before they added more money to your annuity, an additional BIC would need to be signed. And so this is why you're going to start seeing more and more carriers removing the ability to add flexible premium starting in month 13. And again, this is I'll recap and I'll go over some of this slower here in just a couple of minutes. All right, so one last thing I want to cover before we get to the agenda is this whole business of the financial institution. And I want to talk to you about this because I've talked to a lot of reps and a lot of advisors, and I know there's a lot of frustration out there about changes taking place, RIAs and broker-dealers really tightening down on what they're doing and why. And I want to just explain a little bit that might help you understand why an RIA or a broker-dealer might be making some of those changes that you may not be comfortable with. They may feel very controlling and arbitrary to you, but I want you to understand that the entity who will be acting as your financial institution is going to be taking a lot of risk for the sales you make going forward. And in addition to the risk, they must provide the framework to ensure compliance. They must provide those disclosures. They must provide a compliance officer to mitigate any conflicts of interest that may exist. They must develop a new web page where clients can go out and read information about the business model and conflicts and get more information about compensation. And again, starting in January of 2018, they're going to be required to sign the BIC. So they're going to sign with your client and they're going to attest to the fact that you didn't break any of the rules that the rule has written into it for a sale they didn't witness. So I don't think any of us like the BIC, and I think it's very onerous, and I think it's one of the things that people are fighting the hardest against within this rule. But if you have a broker-dealer or an RIA that's coming out to you and saying, hey, we've got no choice to make some changes, trust me, there are reasons behind those decisions they're making. But let's get back now to what happens next week, and let's start with the most important question. Does this rule even impact you? Well, as of June 9th, a fiduciary is any individual receiving compensation for providing advice that is individualized or specifically directed to a particular plan sponsor, plan participant, or an IRA owner for consideration in making a retirement investment decision. These decisions can include, but are not limited to, which assets to purchase or sell, and whether or not they should roll over funds from an employer-based plan to an IRA. So this is a big deal. This covers almost everybody on this call, I imagine. So once you are subject to this rule and working in the effective market, as of June 9th, you must meet new standards and follow new guidance. In other words, this rule goes way beyond a disclosure form, and it goes way beyond the existing fiduciary rules in effect. And so even if you are a fiduciary today, this rule will impact the way you do business going forward. Beginning June 9th, you will now be subject to impartial conduct standards, including giving prudent advice in line with the client's best interest, avoid misleading statements, receive no more than reasonable compensation. And while you may be doing these things today, you have to understand that these are now legal terms that you may have to defend to the Department of Labor, you may have to defend to the Internal Revenue Service, or you may have to defend them in court. Specifically, for example, let me read to you the standard of impartial conduct. It states that at the time a recommendation is made, that it must be made with the care, skill, prudence, and diligence under the circumstances then prevailing, that a prudent person acting in a like capacity and familiar with such matters would use in the conduct of an enterprise of a like character and with like aims, based on the client's financial objectives, risk tolerance, financial circumstances, and needs, without regard to the financial or other interests of the advisor. And that might sound straightforward until you're on the defense side of a lawsuit. And so I just want you to be aware that it is not business as usual next week, and we do need to help you make sure that you are doing the proverbial CYA. In addition, starting next Friday, you will be required to provide necessary disclosures that reveal your fiduciary status, disclose all material conflicts of interest as defined under the rule, including your compensation, and those disclosures are going to be your responsibility. So as of June 9th, there is no financial institution in general required to make sure that you're using the right disclosure, that it has the right language, or that you're actually obtaining them. No, instead what most carriers are going to do is they're simply going to have you sign some attestation form that says, yep, I did it, but they're not going to ask you for this form. Now, most of the carriers we work with are providing these for qualified sales as of June 9th. I know, for example, if you work with Allianz, you've probably been inundated with all of the information they're sending out on their sample disclosures. But if you go back and you read the correspondence, you're going to see that they are telling you that these are sample disclosures with sample language for you. Now, we've looked at several carriers' sample disclosures, and honestly, some were good, some were okay. All of them were written by attorneys. And so we felt like perhaps it might be complicated for you, especially if you are sitting down with a client and you're selling them, say, an American Equity annuity at the same time you're selling them an Allianz annuity, that you might have to get two different disclosures completed because of the language contained within. So what we did, and I'm sure other organizations you work with are doing the same things, we went out to our compliance team and we had them, in conjunction with the carriers and the legal team, create our own document. So we do have a document that can be used regardless of carrier, and if you would like a copy of the one we have, again, no obligation. You don't have to work with Insurance Network to use this. We just really want to help whoever we can. Give us a call at the end of this and we'll get you a copy of ours. This disclosure, again, just a few things that it has to include in it, and ours has everything the Department of Labor requires. It's going to require an acknowledgement of your fiduciary status and what that means. It's going to include the standards you used for your recommendations to your client, that care, skill, prudence, and diligence. It's going to have an acknowledgement of the compensation, and that is going to be in terms of a percent earned in the first year, percents earned in future years. I have seen some out there that take that then and break it out over the life of the contract to say, hey, you know, I might be making 6%, but if you look at that over the course of the contract, that really equates to maybe 75 basis points. And so I do see some of those out there. You can certainly do either. There is also, in most cases, going to be a need to designate a person to mitigate conflicts of interest, that financial institution we talked about, depending on the products that are sold. So again, what I would just tell you is you can use your own, you can use the carriers, you can use your broker-dealers, you can use ours. Just make sure it includes these things. And then my advice to you again would be to understand one thing that's really critical. This disclosure form is your responsibility. As of now, no one else is on the hook for you getting this. And so you want to make sure that you're getting it, and you want to make sure you're keeping it on file, and we'll talk about that a little bit in a minute. Other things that an advisor should do in order to comply with everything we just talked about is, given the fact that you have now said that you are going to have a recommendation that is taking all of the client's needs into consideration, and you're probably already doing this, I know you're all professionals, but if you're not doing it, you have to start conducting a thorough fact-finding of the client's financial picture and their needs to ensure that the products that you're recommending are in their best interest and meet those needs and those objectives. I can tell you right now, even without this fiduciary rule, that stuff comes up all the time. I saw something come across my desk yesterday. There was an advisor in the state of Washington. The advisor made a recommendation to a client who in the conversation mentioned that they might need their money back within a few years in order to, put money into a remodeling of a house. And the advisor said, well, then we ought to add this rider, because this rider would give you a full return of premium at any time you wanted it, no questions asked. I've looked at it. I think that the advisor did everything that they thought they should do. And they just got fined $1,500 by the state of Washington, and now their insurance license is at risk. And part of the problem appears to be perhaps the amount of documentation that the advisor may or may not have had. Uh-oh, are we flashing over there? My screen's flashing. Hopefully it's not scrapped. Hey, Tom, is the screen flashing on your?
It was, it stopped. You're good.
All right. It probably was trying to tell me to be quiet and hurry up. So anyway, just be aware that you need to be doing that. And again, we'll talk about some things that we have for you. You need to review your marketing materials to ensure they don't include misleading statements. You need to look at marketing, how are you getting people into your door? Look at your seminar materials. Look at your emails that you're using. Look at your seminar invitations. Just be sure that you are documenting and being really careful. And if in doubt, have a compliance expert take a look at this. If you don't have one with your current IMO that will do that, please reach out to us and we'd be happy to help you with that. Again, our goal is to keep you out of trouble. Also, another biggie for you is please, please, please call your E&O carrier and make sure that they have added language to include protection for complaints that may arise out of these new standards. We have 3 that we have recommended for different reasons at different times to our advisors, depending on their needs. All 3 of them have either added the language or in the process of adding this language so that it will be there on June 9th. But you need to ask the question, make sure you are protected. I think that sometimes when new things come out, the real question isn't, will I get sued, but when will I get sued, or when will a complaint come out, and can I defend myself? Which leads me to my next comment. If you're keeping all of your client notes on a yellow pad and putting it in a drawer, and if your desk looks anything like my desk looks about half of the time, this is a problem. You have to have an organized structure for documenting all of your client communications, not only during the sales process, but the discovery process. How did you find this client? How did you meet them? What did they see? A Facebook post? Was it a seminar invitation? Was it an email, something you sent them in the mail? Was it a referral? How did you meet them? What did it look like? You've got to make sure you're documenting these things. One of the things I talked to somebody about recently was, in fact, I talked to a broker-dealer about this, and he said, here's my biggest fear. My biggest fear isn't that we're going to get a complaint a year from now. My biggest fear is that we're going to get a complaint 10 years from now. And 10 years from now, we're going to get a complaint, and it's going to come from a beneficiary. So the person that the rep sold the product to isn't going to be around anymore. A beneficiary is going to be saying that this product was not in the best interest of their loved one. And then we're going to go out to reach out to the rep to find out what his notes were, and he's going to have retired. And the person that took over his practice can't read his notes on that yellow pad, even if he can find it. You do not want to be in that position. So we're going to need to make sure that if you don't have it already, you do have a means of documenting all of those communications and sales processes. So what else do you have to be doing at the time the rule kicks in? What else is required? Well, I just said it, documentation requirements. Whether you're keeping them on a yellow pad or you are keeping them, in a desk drawer or they're in your computer, you're going to have to retain them for 6 years. So those signed disclosures, 6 years. All of the, pre-sale conversations, 6 years, so that you can, defend it again. There's also some training requirements. Interestingly, these training, programs didn't even exist. And so that's one of the challenges that has been taking place is how do we fight this? How do we comply when there aren't any training programs out there yet? Well, some of the carriers have been coming out with training of their own. I know LIMRA is in the process of finalizing theirs. So there are some training programs that I expect you're going to hear a lot about in the next few weeks. Take the time to take one. Take the time to make sure you attend as many of these types of sessions as you can. Take the time to research on your own and make sure that you're doing what you need to do so that if a compliance officer from the Department of Labor or the Internal Revenue Service or whoever else it may be comes knocking on your door 3 years from now, you have the ability to say, yes, I knew this rule went into effect. Yes, I knew these things. These are the things I did to comply, and this is what happened in this particular sale. I will tell you, we see about, 5 or 6 complaints a month, usually coming from departments of insurance. Usually somebody's, other advisor, their brother-in-law or a CPA has drafted a letter to the Department of Insurance. We win every single one of those when the advisor has taken good notes. So just make sure that you do your due diligence and kind of follow those through. So let's talk a little bit about market disruption and what happens to the business the day after the rule goes into effect. What's going to happen, how much, and why. So product changes. Well, we're already seeing that. Last month, you saw Allianz announce that their flexible premium products are no longer going to be offered with any more than a 12-month flex premium provision. They did that to eliminate the need for the second BIC. American Equity just announced a whole new slew of fixed annuity products, not fixed indexed annuity products, but fixed products that have income riders to rival those of fixed indexed products because they're trying to avoid the BIC altogether. They want to keep things under this 84-24 permanently versus only until January. We have seen other carriers doing similar things. We've seen broker-dealers looking to change their policies of annuities being considered outside business activity, and some of them are running commissions through their grids to ensure that there are no conflicts of interest from a reasonable compensation standpoint. Insurance-only agents are retiring. Others are looking to get at least their 65 to see if that will help them. We've got competitors out there telling insurance-only agents that they might as well hang up their hat unless they become Series 65 or get their 6 or 7. There's just so much going on, and unfortunately, I think what happens when there's so much going on is we become a little bit paralyzed because we don't know what to do. I'm going to say a couple of quick things, and I've been trying to stay off my soapbox so far. Sometimes you have to follow the money. Sometimes you have to ask yourself, what is the motivation behind the advice somebody's giving me? And if you are an advisor who is an insurance-only agent and you want to start offering other products, you want to start being a more holistic advisor, and you want to take this worry of source of funds completely off the table, then by all means, take a look at the 65, the 6, the 7, take the step. But if you're an insurance-only advisor and you have no intention of doing anything other than insurance products, you're going to get yourself into more trouble than not if you go out and you do one of these RIA in a box and become an RIA solely for the purpose of selling insurance products in the qualified market. So just take some deep breaths, educate yourself, and ask yourself to follow the money. Broker-dealers bringing things in-house, honestly, I will tell you that most of the time when a broker-dealer takes something in-house, the marketing organization like Insurance Network takes a haircut. And so I say this with all sincerity. When a broker-dealer comes to us and say, hey, we're going to need to get a piece of the pie, we're bringing this in-house, we're trying to do the right thing by our advisors, I get why they're doing it. I really get why they're doing it. Their risk is going up, and they're going to be held accountable for what their reps are doing. And so most of the ones we're talking to are doing everything in their power to keep your compensation whole by getting people like Insurance Network to help cover the additional expenses associated with becoming your financial institution. The other thing that I would say is that, you know, this whole issue of levelized compensation and reasonable compensation, every carrier we have talked to has indicated that they believe, after much review of this rule, that the compensation they offer today is reasonable. So in fact, I'll tell you, I've seen several raise commissions effective next week. Most of them that are doing that because their bonus programs are having to go away, and so they're just bringing in higher compensation for the advisors. I think that is very admirable. I think those carriers are doing the right thing, and I think that proves the fact that those carriers aren't just using this as an excuse to cut your comp. We're just all in this together, and we're all trying to navigate it at about the same time with, frankly, very little information coming out of the Department of Labor. And some of what does come out is very conflicting and confusing. And so I get why there's so much kind of angst. Meanwhile, here's the problem. We have customers who need us, and we're all distracted. And we need to get back to work. We need to get back to work providing your clients with the only product in the world that can provide them with both the peace of mind and the guaranteed lifetime income they can't outlive. So we got to get past all this noise, and we got to boil it down to make it simple, and we've got some ideas about how to help you do that. So let me just really quickly swing to that, and then we'll go to questions. So what do we have in place for our advisors that work with us to ensure that they're compliant and able to meet these requirements? Well, for those advisors who work with INA who do not have a good contact management system, a good business management system, something that they can keep track of all of this correspondence and their clients, we've got one available for them at an extremely reasonable discounted price. We are co-opting that with one of our partners to make sure that it is very affordable to you. We do have a best interest platform that will provide the process, the disclosures, and the documentation that you needed to comply. And once you do need a financial institution, assuming you're an insurance-only producer, there is a financial institution tied to that, and I'm going to get to that in a minute. And again, we do have recommendations for E&O options that are going to provide protection for complaints that may arise from best interest and prudent care standards. It's very affordable. We've done a lot of research on this, and I think you'll be surprised at how affordable it is. So real quickly, I'm going to talk about these. See what we're doing for time. Yeah, we're at 1:40. So I'm going to go ahead and go through these fairly quickly. I won't have time to do any demos because I do want to leave some time on here for questions. But again, we've got a great team. Pick up the phone, we get off the phone, and we'll get you the things that you need. So let me just really quickly walk you through what our contact management system is. It's called Smart Office. It's by eBix. We have used it in our office for the last 5 years. It is fantastic. It stores everything you need to know about your clients, what policies they have with you, what investment accounts they have with you. It integrates with other programs. It is just outstanding for capturing the information that you need. Important dates, financial pictures, tracking family members, emergency contacts, the goals and interests of your client, provides everything you need to do a really good annual review. And also there is a component in here that our compliance and marketing team have worked together on to provide you with some compliance approved templates that you can use to market and communicate and educate your customers to perhaps get them interested in more products that you have. I don't know if you have this problem. I think it would be more likely than not that you do. Most of us have customers that don't know everything we have available, right? You know, we sold them a product, they know we're an expert in that, but they don't know about the 17 other things we can help them with. This marketing and communication tool will provide that for you, and we're going to do it in such a way that you have everything ready and it's a matter of pushing a couple of buttons. The best interest platform that we have partnered with is called Assess Best. This was put together by an association who has been behind indexed annuities and insurance products for as long as I can remember. Fantastic people. There are 45 marketing organizations who are charter members of this and can offer this program for only $199 a year. It's normally, I think, $350 a year plus some additional expenses. Talk to our team about other discounts we might have available to you. But if you're not working with Insurance Network and you're just interested in doing this, you can go out and you can work with them. You just have to pick one of the designated charter members in order to affiliate with. But it is not IMO specific. So you could choose us in order to get that $199 rate. Choose, you know, one carrier you might work with us, and then load up all of the other carriers and products you work with other IMOs with, and that's just fine with us. Again, our goal, certainly we would love to earn your business, but that's not the only reason we're doing these webinars and the only reason we're bringing these platforms. Frankly, we're worried about you, and we're worried about some of the misinformation, and we're worried about the lack of tools we think that are available to you. And since 2017, it's all on your shoulders. We want to make sure you have the tools you need. This particular program documents all of your client communications during the discovery and sales processes. It has built-in client fact-finding. It has a built-in report that you can provide. It does uncover some, perhaps, guaranteed insurance product needs that they might have, they might not be aware of. This is probably not the best product if you are Series 6, 7, or have your 65. This might be more in line with an insurance-only producer. We do have others available. I wasn't talking about them as much today because if you have other, if you're a registered rep, you probably have a good system out there. I will say if you're using Money Guide Pro or if you're using Riskalyze, that Smart Office program I talked to you about a minute ago does integrate with those programs, and we can get you some discounts on both if you want to talk to us about those. The Assess Best program also has a seamless process in place to ensure that all the disclosures are, it just creates them and it allows you to email them and get an e-signature and have that put right back into the program. And so I think you're going to find it to be pretty slick. We looked at a lot of them before we landed on this one. One of the things that we also liked about this for an insurance-only producer is right now it's very up in the air who could be your financial institution. And in January 1, 2018, you're going to have one. So we have a RIA partner affiliated with this Assess Best program, and they have agreed that if you pay that $199 and you follow the steps within their program, which is very user-friendly, they will be willing to sign the BIC for you for a very reasonable price. So I'm going to kind of stop here and just talk a little bit about what's next. You know, we're in this together, and we're going to continue to advocate on your behalf in Washington, D.C. Tom and I leave in a couple of weeks. We're going to be there for 4 days with the National Association of Fixed Annuities. We are fighting very hard. There are some congressional bills that have already left committee that would kill this thing. We're going to be up there talking to your representatives and ours about how we can get them to get this through the Senate and the House all the way, which would make all this go away. That's an uphill battle. I tell you, the minute you say that you are not for putting the client's best interest before the advisors, the sound bites just kill you before you're out of the gate. So you've got to have good talking points, and you got to know what to say. If you can't meet us in June to join us for this On the Hill March, let me know. We will also get you the information, the talking points, and you can send emails, letters, phone calls. Talk to your legislators that are back there representing you in Washington, D.C. They can help put pressure on this. Learn more about the platforms available that will provide you with that clear path to compliance. I hope I've given you a pretty good idea. I know I've gone through it fast. I apologize for that. There's so much to go over. So if I've missed anything, we're going to go to questions in a minute, and I'll try my best with Tom to answer those. But make sure you call your annuity specialist at Insurance Network. If for nothing else, call us for 3 things. Call us to get a copy of that disclosure document and the instructions that we've developed that you could use across all carriers. So call us to get a copy of that. Again, no obligation. If you just talk to one of our annuity specialists about your business, we'd be happy to get that to you free and no obligation. Call us and talk to us about the AssessBus platform and how you can access that. We can get you some additional information. We could get you on a webinar that is nothing but that platform. We didn't do that today because I know a lot of you on the call are registered reps, and so we didn't want to do it in case that wasn't of interest to you. Talk to us about the contact management system that we have available and what our recommendations for you are. You know, I think the best thing we could do for you right now is to have an individualized conversation with you about what you're doing, how you're doing it. Are you insurance only? Are you a registered rep? Are you an IAR? All of those things matter. And the thing that I say in the bottom right hand, this has been our company motto for a very long time, is that we specialize in people over products. What that really means is we specialize you over the sale. So we want to help you. And if we help you, and as a result of that, you want to do business with us, fantastic. One last slide that I would throw up here, that's our contact information. I'm actually going to skip over that because our phone number is also on this one. I would love to invite you and encourage you to attend our Summit 2017. Our summit is a free event. We do not charge you anything for the speakers, the venue, the meals. We cover lunch and dinner, networking events. We cover all of the keynote speakers. The only thing you've got to do is get here and pay for your hotel. But the actual event, we spend about $1,000 per producer on this or per attendee on this event. It is a very expensive investment, and it's one of our favorite things we do all year. Reinvesting the revenue we earn back in the advisors in the field, giving you the things you need the most. Brian Tracy, who, if you have not heard Brian Tracy speak before, he is absolutely one of the best. He used to travel around with Zig Ziglar a lot. He is going to do a sales strategy 90-minute session. Whether you've been at this for 3 months or 30 years, he's going to teach you something about that. And then he's going to talk to us about how to stay productive despite all of the distractions. I believe we are right now up to 26 sponsors, carrier sponsors, and industry sponsors that will be at the event. I believe we'll have close to 30 breakout sessions for you to choose to attend that are all about how to market better, how to sell more, learning new products, learning new strategies. But I'll tell you what, the networking at this event is probably the best of anything you've ever seen. So talk to our staff. Again, registration is free. It's an invitation-only event, but consider yourselves all invited. And we would absolutely love to have you in September here in Boise, Idaho, which is where our headquarters is located. Tom, I talked really fast. I hope I didn't talk too fast. Do we have any questions that you'd like me to address?
Yes, absolutely. And if you haven't submitted any questions, again, feel free to do that within the menu. Should be at the right hand of your screen with the go to webinar menu. Easy for me to say. First question, Lori, is could you clarify more on what would constitute a misleading statement?
I would love to. However, the Department of Labor has not been very forthcoming. I think that's one of the biggest frustrations that we have. I've tried really hard to stay off of my soapbox on this call because I know we have a lot of strangers that don't know us very well. But I'll tell you, that's one of the most frustrating things. They come out and they tell you, hey, you know, you have to comply with this, but they don't really define it. Reasonable compensation, misleading statements. I have a good friend on the board of directors with NAFA who was in a meeting with a high-ranking person at the Department of Labor under the Obama administration last year, and he asked that question. You know, how are we going to define exactly what it means by misleading statement? How are we going to define exactly what you mean by reasonable compensation? And this Department of Labor individual told my friend, we don't plan on defining any of that. We figure the courts will settle all that. So I can only offer you my advice. I can only offer you my advice based on what I've seen. And what I've seen get people into trouble. If you are doing a seminar and your seminar invite looks like it's coming from the Social Security Administration, and nowhere on there does it say that there could be an insurance presentation involved, you probably need to add that disclaimer. If you are making a statement to the client that says, there is no way that you could ever lose money in this annuity, you probably need to caveat that with, as long as you meet the terms and agreements of the contract. So let's make sure that you're not going to need money sooner than the surrender period expires, and let's make sure that if you do, that it doesn't exceed the free withdrawal provisions. You're just going to have to be a lot more diligent in making sure that they understand them. I will tell you that they do consider the omission of any conflict of interest to be a misleading statement. So because they consider your compensation to be a conflict of interest, if you don't disclose that, they would consider that to be misleading. They do consider it to be a misleading statement if you overstate your expertise. So if you're out there with a business card that says you're a financial planner and your highest level of licensure or education is taking a life test at your state for the Department of Insurance, you might want to rethink how you have that worded on your business card. So I wish I could tell you it was more clear. It's one of the reasons we really thought we were going to get this second delay, because it's not clearly defined yet. And you know, we've only had a Department of Labor secretary for a very few short weeks, and he hasn't had time to work to get any of this done. And so I know that didn't really answer the question, Tom, but that's the best I can do.
I think you did fine. Next question is, does INA, Insurance Network America, have an established relationship with an organization that is willing to be the financial institution for our agents once the BIC is required on January 1st, 2018?
Yes, that was a huge priority for us. You know, we intended to be a financial institution, and we intended to be the one signing your BICs. We felt that we were closest to our advisors. We felt we, especially an organization like Insurance Network, where we really, really work hard to get to know you and get to know your practice, we were willing to take the risk, spend the money, do what it took, and become a financial institution. And everybody thought that that would be a pretty clear path. And in fact, the Department of Labor, even Obama's Department of Labor, had indicated they were going to create a very clear path. They didn't. In January of this year, they came out with their proposed IMO exemption that would allow us to become financial institutions. And the requirements for premium alone were so huge. I mean, $1.5 billion in each of the last 3 years in annuity sales was the threshold. And there are only 5 or 6 organizations in the country, even those that, like, Allianz, for example, owns several IMOs. Even when you start adding up all the ones that are merged together and have common ownership, there's less than 10 in the entire country that meet the requirement of premium. And then there are other requirements on top of that. And so I've had personal conversations with almost every single one of them that would qualify, and every single one of them has told me they are not going to qualify. It is too onerous, too big, too much, can't do it. So unless that changes, and there's still a lot of, radio silence on the part of the Department of Labor on this, because it was just a proposed exemption in January. There was a comment period closed months ago, and there's been nothing coming out of the Department of Labor since then. So all of us had to go out and find a partner, and Insurance Network did. We, at this point, have partnered with an RIA willing to sign the BIC on behalf of our insurance-only producers that work with us. It doesn't mean we've given up the hope of becoming a financial institution on our own. We've got until January of 2018 to do that. There've got to be some changes made in the rule for that to happen, but we do have a solid plan B.
Okay, next question is, do we have a list of carriers who have the required compliant forms under the Department of Labor rule?
So you're talking about the disclosure form we just talked about for 8424, I presume, and they're still sending them to us on a daily basis. And so, I would say all of the biggies have them already. Tom, you've been working on that as well. I mean, we've gotten them from North American, American Equity, Allianz, handful of others, right?
Yes, absolutely. We've got them all. And to elaborate, we have developed our own form, disclosure form, that will be compliant. We feel our wording is, it meets the requirements. It is going to be worded in simple terms, and also be more conducive to the sale. A lot of the forms we've seen out there, like Lori mentioned earlier, are written by lawyers and quite frankly don't really put annuities in a good light. So we feel that developing our own that's going to help you and help your business, help your client conversation, was the motivation behind that.
And we have that available now, and so that would be our phone number is up on the screen. I would encourage you, reach out to one of our annuity specialists. Just call that number, ask for an annuity specialist, and we're glad to give you a copy of the form we developed.
Laura, I've got another good question here. Is if an application is submitted before June 9th and then funded after, will this fall under the post-June 9th rules?
Yeah, it is my understanding that it is June 9th is the date of the recommendation. So I would tell you that's a very fine line, and I believe most carriers are going to tell you, and Tom, I know you're a little bit closer to this than I am, but I believe most carriers are going to tell you that it's going to fall under the rule. Is that the feedback you're getting as well?
Yes, yes, absolutely.
Yeah, so funding isn't as important as the time of the recommendation and the taking of the app.
That is correct. And some carriers might say, okay, well, it needs to be funded by September 6th. They'll put a date on if it's submitted before June 9th, they want to see it funded by September 6th. In most cases, if it's after that, they may go back and require further disclosures to be submitted.
So you're saying we can't just submit a whole bunch of stuff right now, even though we know it's not coming for a while?
Well, if we know it's coming before whatever the given deadline is, certainly. And then if you have questions like this, more intricate, call the number, reach out to any of our marketers. We can answer those specific questions for you.
Absolutely. What else you got for me? We're coming right up, straight up on the hour.
Let's see. We've got a number of questions still coming in here.
Well, I'll tell you what I'm willing to do. I'm willing to stay on the line for another 5-10 minutes, even though we're past the hour, and answer. So why don't you just throw them at me, and let's see if we can stump Lori.
Sure. Real quick, this has been asked a couple times. Will there be a link to the recorded webinar? Yes, we are recording this. We will have this up on our website for you to hear parts of it again. If that is helpful, we can certainly do that. Reach out to us, and we can provide more details. Question in, Lori. If an individual has a current 401k from a prior employer and it's still sitting at this plan, would it be prudent to move these funds prior to June 9th? If the intention is to move them anyway, would it save time and effort down the road?
It'll save hassle if you take the app before June 9th.
Okay, and obviously we covered fixed index annuities and qualified money that would be funding a life insurance policy. Is this true for fixed annuities, and is this true also for HSA accounts?
So on HSA accounts, I'm sorry I didn't clarify that a little bit further. On HSA accounts, if you're an advisor and you are simply recommending that your employer group or an individual purchase an HSA compatible plan, they get the qualified high deductible plan, then you refer them to an HSA bank or otherwise, and they make the decisions within that HSA account what they want to do with the money. You know, do they want to just leave it in the cash account or start investing it? Then you have no worries. If you are the ones recommending to them, hey, you know, you've built up $18,000 in your HSA account, maybe we should take $15,000 of that and invest it. Now you have an account subject to the fiduciary standard. So the HSA account itself isn't a big deal. It's the recommendation of the investment that's a big deal. On life insurance, fixed annuities, SPIAs, those all fall under 8424, and so you will have to be doing the disclosures if the source of funds is qualified money.
Okay, I think we're close to the end here. I think there's one last question here that we'll touch on today. And Lori, you know, I'm paraphrasing this one a little bit, but I think you'll enjoy it. If I'm with another IMO, why should I move to INA?
Well, I don't know if you should. You know, I think that you have to look at your marketing organization as your partner. And I think if you have a great relationship with your IMO and they're a great partner and they're providing you everything you need to navigate all of this, then I certainly think you should stay there. I know that might sound backwards from a sales organization that we feel that way, but I think your IMO should not be viewed by you as just a product source or the best contract source. I think your IMO, especially in this new world, should be viewed as your partner. And so if you're looking for a marketing organization that partners with you, if you're looking for a marketing organization that quote unquote knows your name, you know, the old Cheers thing, where you are never a little fish in a big pond. If you're looking for an organization that is going to put your needs before our needs, that's going to be more important that we take care of you and your client than we make a buck, then we're probably the right IMO for you. And we would love a chance to just have that conversation. So I didn't do this, and Tom didn't do this, and the team didn't do this webinar or the series of webinars in order to try to, you know, steal agents from other IMOs. That's never been our business practice. Our business is we want to earn your trust, earn your business, partner with you, and do that every single day for the rest of our relationship. And if you're looking for that kind of organization, we would love to have a conversation with you.
Well said. I think with that, we will wrap up today.
Super.
And Lori, go ahead.
Well, I just can't thank you all enough. I mean, like I said, there were several hundred people on this call, and as I look at that, what that tells me is that you guys just need help, and you have a lot of questions, and I really hope I answered them. I know I went fast, and I apologize for some of that. It's just, like I said, there's just so much. Tom did indicate that this webinar will be up. Our Director of Marketing, Austin Blaylock, does a great job of getting these downloaded and recorded and up on our website. Our other ones are up there too, and so some of it will be repetitive because I did go through, you know, a little bit of a recap. But if you want to go through any of our resources, our website's down here at the bottom, the www.insurancenetwork.com. Go listen to the session again, see if there's anything. But, you know, I'd say this, to heck with the webinars, pick up the phone. We have got the best team of annuity specialists in the industry. You want to talk about why you should work with INA? It's our team. So between them and our administrative support staff, we're in this with you. So we would just like to continue to be in this with you if you want to give us a shot at that.
Great, thank you. I want to thank everyone. Go ahead, I'm sorry. And come to the summit.
Come to the summit.
Yeah. I want to thank everyone again for joining us today. Any further questions, reach out to us, 800-456-7999. If you want to look at those, the disclosure forms, things we can do to help you in your practice, reach out to our marketing specialists. We're here to help you. Again, thank you so much. Have a great day.
I agree. Thank you, Tom. Thank you, everyone.